Hey everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with notice. There is a lot of information in this video. So a couple of things I want to bring to your attention, and all of this information is contained in the purchase and sale agreement. If you think about it, the purchase and sale agreements are nothing more than a set of instructions to everyone, what they are charged with doing, what the instructions are to get from a binding contract to the closing table. But specifically with regards to notice, let's talk about notice. There's a couple of things you need to know about. So first of all, in the GAR, Georgia Association of Realtors Purchase and Sale Agreement, the information is located, the GAR Purchase and Sale is F20, and the information is located in the paragraph C, Other Terms and Conditions, paragraph C1 under Notices. Now, there is a lot of information. So, first of all, in general, the notice must be in writing and must be signed by the party giving notice. So, let's stop right there. Agents, you guys have got to stop emailing agent to agent when you are giving notice on behalf of your client for someone. That does not satisfy the terms of the contract of notice in writing. It is in writing, but it is not signed by the party. You as an agent are not an essential party to the contract. Only the buyers and the sellers are the essential parties to the contract. So for example, if somewhere in the contract it uses the term notice, then that needs to be handled on the proper notification form. Now, in both the GAR and the RE forms, there are certain forms given a specific situation where you're going to send notice. But in general, if the contract calls for notice, just as an example, so you can think about this, where it talks about in the GAR contract paragraph B1B, examination of title, it says buyer may examine title to obtain and may obtain a survey, and may furnish the seller with a written statement of title objections at or prior to the closing, so forth and so on. Again, there's all other places throughout the contract that says notice. That does not mean that the listing agent sends the selling agent an email regarding, hey, we just found out there's a lien on the title and the seller needs to take care of it. When the contract calls for notice, here in paragraph C1A, it says the notice must be signed by the party giving notice. So if it's just a general notice, in the GAR form, you are going to use form F135, and it is called notice. This is the most underutilized form in the whole GAR contracts package. And in that, you're going to fill out the notice, what the information is, and then you're going to have either the buyer or the seller signing it. There is a similar form in the RE contracts packages. It's called notification, and it's RE260. Notification, same thing. Those two forms are for you as the agent to fill out whatever the notice is if it's not specifically handled in an amendment, and you fill out the information, then you have your client or customer sign it, and then you send that to the other party. So that's the very first thing we have to talk about. Must be in writing, signed by the party giving notice. The next issue is what forms of notice are acceptable? Well, the GAR contract says the requirement of the notice in this paragraph shall apply even if this agreement is becoming binding. Notices shall only be delivered, number 1, in person, number 2, by courier or overnight delivery service, or by certified or registered U.S. mail, or 3, by email or facsimile. The person delivering or sending the written notification signed by a party may be someone other than that party. So you as an agent or a courier service or any other person delivering the notice, that's acceptable, but the notice itself must be signed by the buyer or the seller. Then, delivery of notice. So how do we know when the notice has actually been delivered? Again, we have specific information so that you know. In the GAR contract under F20C1B, delivery of notice, the notice to the party shall be deemed delivered. In other words, the party who is sending the notice, it is considered delivered to the other party when one of the following occurs. In the case of delivery by delivery service, when the written notice is delivered to the address of the party set forth herein, or subsequently provided to the party by giving notice provisions herein, provided that a record of the delivery is created. So if you're using a courier service or FedEx or UPS or any of the delivery services, there must be a record of that delivery. That means if you're sending the notice by U.S. mail, it must be registered or certified, so there is some tracking for that. And it also says that notice to a party shall not be effective unless written notice is, I'm sorry, I skipped something. Delivery of notice. Case of delivery service. When a written notice is delivered to the address of the party set forth herein, or subsequently provided, or in the case of delivery electronically, on the date and time the written notice is electronically sent to an email address or fax number of the party herein, or subsequently provided to the party following the notice provisions herein. Notice to a party shall not be effective unless the written notice is sent to an address, fax number, or email address of the party set forth herein. Okay, so let's think about that. So there are three forms of notice: by delivery to an address, a physical address, or electronically by fax or email. Now, it also says that the notice is deemed received when the sender can prove they sent it, in the case of an electronic delivery. So when the fax, if you're sending it by fax, when you get that fax confirmation, or if you're sending it by email, the person sending it, they need to prove that that full attachment was included to an email to the other party. The date that that email was sent with the attachment, that's when it is deemed delivered to that other party. Now, when is a broker allowed or authorized to accept notice on behalf of a client? Well, number one, that party must be a client. So unless the broker is acting as a dual agent, in general, if the broker is representing the party, the buyer or the seller, as a client, you'll know that because the first page of the purchase and sale agreement under the agency relationships in paragraph 10, brokerage relationships, it'll say the selling broker is ABC Brokerage, listing broker is ABC Brokerage, and it'll say representing buyer as a client or representing seller as a client. So if the broker is representing the party as a client, which you will know because that's marked on the agency agreement on the first page of the contract, then the broker or the affiliated licensee or the staff at a brokerage may accept the notice, and notice to the broker, affiliated licensee, or the staff is deemed suffices as notice to the party. Now, if it is a designated agency situation, then the notice must be given to the agent specifically representing whichever party. So designated agency, the broker is going to designate agent A to have a client relationship with the seller and designate agent B that has a client relationship with the buyer. So in that situation, notice is fulfilled when the notice goes to the agent that is actually working with that specific party. So what about in a dual agency situation, or if the broker is working with the public person as a customer? Well, in that situation, it says that notice to the authorized agent doesn't suffice. So if you are working, if it is a dual agency situation, or if the broker is working with the customer, now that public person is still a customer of the brokerage. So as a courtesy, agent to agent, you guys are still going to go through the agents. However, for the purposes of notice per the contract, notice to a customer, and again, you'll know that under the agency section of the purchase and sale agreement. If it says selling broker is ABC Realty and is working with buyer as a customer, then notice to the broker or the affiliated licensee does not satisfy the terms of notice. Notice must actually go to that customer, the buyer or the seller, directly. Same thing in the case of a dual agency situation. And again, from the previous paragraph, the notice must be in writing, signed by the party, and must go to the physical address with a record of delivery, or an email or a fax number, provided that those numbers are the ones provided in the purchase and sale agreement. So on the signature page of the purchase and sale agreement, if you are working with the buyer or the seller in a client relationship, then all you would need is one of those three forms of notice. You would need the broker's address where something can be delivered. You would need the broker or the affiliated licensee's email address or fax number. So again, in a client relationship, notice to the broker, affiliated licensee, or staff of the brokerage serves as notice. In the case of dual agency or customer, notice must be delivered directly to that customer. So you as an agent, first thing you should do, when you get a purchase and sale agreement, you look on the agency section. If it says ABC Realty is working with the seller or the buyer as a customer, the very first thing you need to do is turn to the signature page and make sure that for that buyer or seller, you have one of those three forms of information, either their address, their fax number, or their email address. If it's a client relationship, that information for the broker suffices. The other thing with this is that information must be provided in the purchase and sale. So you might have a situation where an agent has an email address that is given to them by their brokerage, Dana@MaximumOneRealty.com. However, let's say in practice I use something, an email address that I purchased myself, something Dana@thehousesoldname.com. If that's what I use in practice, but when I pull out my forms, my Maximum One email address is what prints here, the notice must go to this email address printed on the contract. So even though as an agent, let's say I'm emailing from my cute email address, Dana@thehousesoldname.com, that does not satisfy the terms of notice because that wouldn't print on here. So you can change that in your preference section on either RDocs or in Georgia MLS and Transaction Desk. You can change what email address auto-populates on your contracts. If a physical address or an email address or a fax number changes, you need to provide notice to the other party that that is changing in order to satisfy the terms of legal notice per the contract. So again, a couple of things to remember. And in the RE Forms contract, all of this information is the same, and this is all spelled out in the standard terms for the purchase and sale of Georgia real property. At Maximum One, we have a policy that if the parties go binding on an RE Forms contract, the agents must include the standard terms and reference them as an exhibit. If you are not a Maximum One agent, you need to check with your broker what their policy is. But as a practicing agent, you should get in the habit of definitely making sure that you print the standard terms and attach them as part of the contract to make sure that the buyer and the seller get all the information that they need. So in the standard terms, it's RE1. Under paragraph 10 is where it talks about notices. And same information as I read for the GAR contract. It must be delivered by hand, overnight courier, such as UPS or FedEx, sent by fax or email, or by U.S. mail, registered or certified return receipt requested. And the only difference is in the RE Forms contract, it doesn't have the paragraph about delivery. But it does say that email does suffice, but it doesn't specify when email is deemed delivered. Now, in both, and it also does say that the fax number, email address, or address must be delivered to that has been notified per the on the contract. So in other words, on the signature page of the purchase and sale agreement, notice must be delivered to that email address, that fax number, or that address. Just in general, telephone numbers, a telephone call, or a text, because a text is done through a phone, does not satisfy the terms of legal notice. It is not in writing, and it says telephone numbers are given for convenience of reference only. Notice by telephone shall not be effective. So I think I've summarized, but just quickly, must be in writing, must be signed by the party giving notice, i.e. the buyer or the seller, must be delivered by to an address by ability to make sure that that notice had been delivered, which would be either certified or registered, return receipt, some method of knowing that the deliverer delivered it to the address by fax, and be able to prove that the sender emailed that, by fax, the fax confirmation that you would get back, or by email. And in the GAR contract, it specifically states that when the sender sends it with the attachment, that is deemed delivered. Those are the forms of notice that are acceptable, and it must, that address, that fax number, that email address must be identified in the contract. On behalf of agents and brokers, if the agent and the brokerage is working with the public as a client, notice to the brokerage, notice to the affiliated licensee, notice to the staff serves as legal notice. In the case of a dual agency situation or a customer situation, notice must go directly to that public person. So a lot of information. I hope this contract tip helps you out. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.